today through our bill, SB 188, the Crown Act, we hope will create a respectful and open workplace for natural hair.
What a wonderful introduction to this conversation. Hello and welcome. I am Kimberly Jeffries Leonard, a Crown champion and supporter, and I am thrilled to be here to talk about how to protect yourself if you feel you've been subjected to race-based hair discrimination and the ACLU's role in protecting your rights. So the American Civil Liberties Union was founded in 1920 and is our nation's guardian of liberty. The ACLU works in the courts, legislatures, and communities to defend and preserve the individual rights and liberties guaranteed to all people in this country by the Constitution and the laws of the United States. That's pretty powerful. We have sitting here representing the ACLU our dynamic and impactful guest, Ria Tabacco-Mar, the director of ACLU's Women's Rights Project. In this role, she oversees the ACLU's women's rights litigation. Previously, she was a senior staff attorney with the ACLU's Lesbian, Gay, Bisexual, Transgender, and HIV project, where she fought gender stereotypes, sex segregation, and attempts to use religion to discriminate in schools, at work, and in public places. Ria was part of the ACLU's litigation team representing Amy Stevens and Dawn Zarda, whose cases were decided as part of the recent Supreme Court ruling recognizing that federal employment law protections apply to LGBTQ people. She also led the ACLU's team in the Masterpiece Cake Shop Limited versus Colorado Civil Rights Commission, the case in which a same-sex couple was refused a wedding cake because they were gay. As you see, Ria is the right person to be sitting here with us today and to provide us critical information on this critical topic. So let's get started. Ria, welcome to the virtual stage.
Thank you so much for having me, Kimberly.
You know, the groundbreaking 2019 Dove Crown Research Study, which was a quantitative study with 2,000 Black and white women, illuminated the impact of race-based hair discrimination in the workplace. It said that Black women say that they are 80% more likely to change their natural hair to meet social norms or meet expectations at work, and that Black women were 1.5 times more likely to be sent home from work because of their hair. Recently, the 2023 Crown Workplace Research Study confirms that the issue of race-based hair discrimination in the workplace is still prevalent, with Black women's hair being 2.5 times more likely to be perceived as unprofessional. And equally concerning, the Dove Crown Research Study for Girls unveils the alarming rate in which Black girls experience hair discrimination. 53% of Black mothers whose daughters have experienced hair discrimination say their daughters experienced discrimination as early as 5 years old. So the Crown Act, which stands for Creating a Respectful and Open World for Natural Hair, prohibits race-based hair discrimination based on hair texture and protective styles, including braids, lock twists, knots in the workplace, and in K-12 public and charter schools. As of today, the Crown Act and the Crown legislation inspired by the Crown Act has been enacted in 23 states, 50 municipalities. This is positively impacting the lives of over 3 million Black people in the U.S. This is calculated based on the Black population residing in the states and municipalities where the Crown Act is law. Now, through Dove and the Crown Coalition, the Crown movement has been a force and is an amplification of the natural hair movement and is supported by Dove and the Crown Coalition's awareness, education, and culture shifting strategies. So now that we're seeing progress, what does one do if they feel they are a victim of race-based hair discrimination?
Well, it's amazing to hear about all of that progress wrapped up so succinctly, Kimberly. You know, when I started doing this work, and I'm old, but I'm not that old, right? When I started doing this work, there were 0 jurisdictions that had passed legislation or had policies that expressly prohibited discrimination based on hair or hair texture. And so to hear you say we are at 23 states and 50 localities, just absolutely incredible. this issue is deeply personal for me as well. As you can see, I do wear my hair in locks. I've had locks since I was 16 years old. And one of my earliest memories of hair discrimination in a professional setting happened in law school when I was interviewing for jobs. And at that time of the year, students are coming in class dressed in interview suits, back and forth. And I was a broke student. I owned one suit and I was wearing my one suit. And I thought I had really cleaned up nicely. And one of my classmates saw me and said, "Hey, you look really nice. You got a big interview today?" And she said, "But you'll never look really professional with your hair and dreadlocks." And that comment just destroyed me. She was the only person to say it out loud, but I felt instantly that this is what everyone must be thinking, what my classmates must be thinking, and more importantly, the people who were interviewing for me for jobs must be thinking, and knew not to say out loud. And I also knew at the same time that I couldn't change my hair. My hair is who I am. I had worn it that way at that point for nearly half my lifetime. And of course, I shouldn't have to change my hair in order to get a job. So it's been a real professional honor for me to get to work on hair discrimination issues as part of my career and the job that I do get paid to do. Because we have seen so much rapid change, right? Going from 0 to 73 jurisdictions in just, 5 or 6 short years. I think when this happens to people, the first thing to do really is education. Many folks still don't know that this is the law because it hasn't been the law for all too long. And in fact, one of the real problems the Crown legislation is responding to is the fact that for so long, we've seen federal courts actually refuse to understand that hair discrimination is a form of race discrimination, right? We've seen courts actually reject claims brought by Black people who have said, if you discriminate me based on my hair texture, right? The way my hair grows out of my head the day I was born, that is race discrimination just as much as if you discriminate against me based on the color of my skin. And courts have just gotten that question wrong. And so many people still don't understand that hair discrimination is a form of race discrimination or that it is illegal. And part of what we are doing, of course, is not just giving people recourse when they do experience discrimination, but we want to prevent that discrimination from happening in the first place, right? We don't want people to be subjected to those hurtful comments. We don't want our children to miss instructional time at school. We don't want people to be turned away and passed over for promotion. So the first step is absolutely going back to your employer, your school, your principal, whoever it may be, and letting them know, hey, this is the law. Did you know this? Right? And taking it upon ourselves, all of us who are in this community, to make sure that we are sort of loud and proud about this new legislation, because I think if we do, we can prevent a lot of these harms on the front end.
From your personal story to what we as a people, as an ancestry, are experiencing and what we can do, it's also very powerful. But you hit on something that I think is even more important for this conversation. The fact that a lot of people don't know that this legislation has passed in so many places. It is amazing to see how many places that we are legally protected now. And the fact that we need to really educate people so that they know what their rights are. What does the ACLU do in these instances if someone comes to you saying that they feel that they've been discriminated against?
We represented a number of children over the years who've unfortunately experienced hair discrimination. And I think I may even have seen some of them in the video. I think of, young CJ Stanley, who was 6 years old and who was denied attendance at a public charter school because he wore his hair in locks. And CJ's story is absolutely incredible because CJ's parents were skeptical that a 6-year-old would be able to tolerate the sort of maintenance that locks require. And so they gave him a long list of things he had to do before he could grow locks, including learning to spell something like 40 words, at 6 years old. And this child was motivated, and he did everything that his parents put on the list. And they said, okay, you've shown us that you're ready to wear this hairstyle. And he was so proud of his hair, and then only to show up at school and be turned away. We have represented students in Massachusetts, twin sisters, who were denied participation in school extracurriculars for wearing their hair in box braids because the school objected to the fact that their braids included extensions, even though white students at the school regularly wore extensions and other hairstyles, obviously allowed to go unpunished. We have sent letters. We have filed complaints. We have filed complaints with the Federal Office of Civil Rights. You should know that the U.S. Department of Education is very interested in hearing about instances of hair discrimination. And in fact, recently, in guidance put out on the race-based use of school discipline, highlighted how discipline can include disciplining students because of their natural hair. So at this moment, we have allies in the federal government. We have allies in many states and localities, and there are many avenues to let folks know and to make complaints.
That's very interesting. It's also very important. I know that so many of us, with natural and protective styles, our children with natural and protective styles, our friends, it's important for us to be educated so we know what we can do if there's that feeling, because sometimes it is overt, but sometimes it's very covert. And we feel that maybe there's something happening, but we're not really sure. And so even for you to tell us what that looks like is important. We've said 23 states, 50 municipalities, any more on the horizon. And those who are in these states, they can come to the ACLU if they feel that that there's discrimination based on race-based hair discrimination. But what about those who are not in these 23 states and 50 municipalities?
So I said earlier that courts have been getting it wrong when it comes to hair discrimination, and they've been misunderstanding hair discrimination. And because we think they've been getting it wrong, right, we're not afraid to go back to those courts and tell them, hey, we think you got it wrong. We want to take another pass at this. So I want to tell you the story of one case involving Chastity Jones. Chastity Jones' case became very high profile because she had asked the U.S. Supreme Court to hear it, and they turned her away. This was a woman in Alabama hired to work at a call center, and she was offered the position on the condition that she cut off her locks. And the reason given to her by HR was that locks tend to get messy, even though Chastity Jones's hair, everyone agreed, was not in fact messy and was very well kept, right? So you talked earlier about the stereotype that natural hairstyles are inherently messy, unkempt, unprofessional, right? They run so deep, even when the actual person in front of us, shows up looking perfectly appropriate. And so in that case, the 11th Circuit Court of Appeals, which is based in Georgia, had said, well, Title VII of the Civil Rights Act of 1964, which is the law that protects most of us from race-based discrimination at work and other forms of discrimination, including, as you mentioned in the intro now, based on our gender identity and sexual orientation. They said Title VII only protects us against discrimination for things that are immutable, for things that cannot be changed. And hair can be changed. So we don't think this is discrimination. And I think there are quite a few things that are wrong with that another court might see differently. First of all, Title VII also protects against religious discrimination. Of course, religion is something that can be changed. People can convert. But more importantly, hairstyles can be changed. Hair texture cannot be changed, right? We cannot change the way our hair grows out of our head. So in effect, what the 11th Circuit was telling Chastity Jones is that she had to chemically alter the texture of her hair, the way that it grows out of her head, in order to be acceptable at work. And it's unfathomable to imagine a court saying the same thing to a white applicant for a job. We just cannot imagine it. Now, that decision is only a few years old, but we have seen a real sea change in our national understanding about hair discrimination since the 11th Circuit case was decided. We've seen all of the legislative action you talked about, so much of it driven by viral videos of young students like Faith Fennedy in Louisiana, kicked out of school for her box braids, or Andrew Johnson, the wrestler in New Jersey, who submitted to having his hair cut in order to compete in a match. And I think that national understanding has reached our courts too. And I think for people who live in the states that don't have express protections against hair discrimination, it's important to remember that hair discrimination is a form of race discrimination. And all of us nationwide are already protected from race discrimination. So we think there is a good argument, and one that should be accepted and perhaps even could be accepted to our advance today, that hair discrimination is a form of race-based discrimination, and it's already illegal.
Wow, that's very important for us to know. And it's very important for those of us who are not in these 23 states and not in these 50 municipalities to know. And so we really, really support the work that the ACLU is doing around this critical issue. Now, if I needed you or if anyone needed you, how could we access the ACLU if we feel we needed the support and protection that you give us?
You can go on our website. We've got intake forms. If you Google it, you'll find it. I'm happy to share the link with you after this chat. And you can tell us all about what you've experienced, and we'll take a look and get back to you.
I think that would be great because I think that is something that, especially when we are celebrating Crown Day, which we know is the anniversary of the inaugural signing of the first Crown Act bill in New York on July 3rd, 2019. And so our hope is that after we're able to amplify these messages, that we will see even more people feeling much more comfortable wearing their hair in natural and protective styles and not feel as though they're going to be threatened with race-based hair discrimination. So if there was one last thing that you could tell us or you would like to leave us and that you would want people to know about what the ACLU does in this space, when you protect their rights when it comes to race-based hair discrimination, what would that be?
I want everyone to know, race-based hair discrimination, we think about it often involving natural Black hairstyles because, of course, it's so common and because it builds on our nation's legacy of chattel slavery. But other people of color experience hair discrimination too. And I wanted to tell you about a student we recently represented, an Indigenous 6-year-old in North Carolina who wears his hair in a long braid down his back. This is part of his tribal culture, and it has been for thousands of years. Men in his tribe wear their hair long, and they cut their hair only when there's a death in the family, and they cut their hair and the hair is buried with the relative as a way of honoring them. This child was told by his public charter school that he had to cut off his hair in order to continue to attend, something that, as I said, he would not do, only to honor a lost relative. And what's interesting about this story is that we are starting to see a growing awareness about Indigenous culture and Indigenous hair. In fact, earlier this month, we saw an opinion from Supreme Court Justice Neil Gorsuch where he referenced the traumatic history at Indian boarding schools and the practice of cutting Native American children's hair as part of that assimilation. And it reminds me of something that the headmaster of this child's school said to his mother when she asked why he had to cut his hair. And he said to her, "We want them all to look the same. We want them all to look the same." And what did he mean by that? We want them all to look like how white boys look. Right? We know who's included in that we, and we know it's not us. But all of us are stronger when we stand together. And so I think it's really important to highlight all of us can benefit from the Crown Act legislation and from understanding that hair is a part of who we are.
That's a perfect way to end this conversation. Hair is the part of who we are, and we are stronger when we are together. And so thank you for the work that you're doing, because we've done a lot, but we have a lot to do. I can't tell you how much we appreciate you being here. We're going to get everyone that link to the ACLU in case they need it. We hope you don't, but if you do, it's there. I want to thank you again for joining and providing us with this very valuable information. And as we continue down the road to Crown Day, remember, flood your feed with all of these statements around what the Crown Act means to you, and follow the Crown Act on Instagram, Twitter, and Facebook. Sign the petition to help end race-based discrimination at thecrownact.com. Thank you, Ria. Thank you again for joining.
Thank you so much, Kimberly. 23 down, 27 to go. Let's do it.
Yeah. All right.